Hello, YouTube. I'm Vince White. I'm an employment attorney, and we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Is it clear that I have said that too many times now? I'm trying to add weird emphasis and make weird sounds. Gotta mix it up. Gotta mix it up. We have a question today from YouTube user NS. It was posted in our video entitled, "Should I get my complaint to HR in writing? Should I keep a copy of it?" Spoiler alert, yes. Get it in writing and keep a copy. All right, NS asked us, I have a question. I have an answer. How does the discrimination and statute of limitation laws work for someone who is still employed by the company? I've not been advised to quit yet, and you only get a certain amount of time. Okay. So it's got nothing to do with whether or not you're still employed. The statute of limitations run from a given act of discrimination, which is what you're dealing with here. You're dealing with discrimination. So I'm answering your question as to the federal laws. This is also true under the New York State and New York City laws, but I don't know where you are, and depending where you are, I may not even be allowed to answer your question. So consult with local counsel. But the way it works under the federal laws, which are often the most important laws, not always, but often, you have a given act of discrimination. Whatever you experienced that you felt was discrimination, that happened. It happened on a certain day. Now, here's where it gets weird. Depending on where you are, the federal laws will give you either 300 days, if there's a state agency that covers this topic as well, or a mere 180 days, if there's not, to get your case filed with the Equal Employment Opportunity Commission. Does that sound like a wild statute of limitations? Does it sound like it's entirely too short and that law is crafted to keep you from bringing your claim? It should, because it was. Politicians are assholes. Now, every day that goes by, let's say you've got 5 acts of discrimination, right? They all didn't happen the same day. They all happened one per day for 5 days in a row. So 301 days from that first event of discrimination, that event falls off. But the other 4 from the next 4 days are still inside your statute of limitations. It is a rolling statute of limitations, right? As the days go by, things will fall off the end, but those discrete events fall off, not the entire case. If there are still events included within your statute of limitations for the federal law, which again could be after 300 days or 180 days, depending where you are, then your specific events of discrimination will still be timely. But wait, there's more. There is something you can try to argue called the continuing violation doctrine, which, if it's a continuing violation, and this I think I actually have a video on this topic already. If you're able to successfully argue that this is a continuing violation, you may be able to string together older things that are older than 300 days for the EEOC statute of limitations, or the 180 days, depending which you're subject to, and include them in, even though they may have fallen off the back end of your statute of limitations already. Okay? Now, continuing violation doctrine, go watch the videos I've made on that. It is a tough road to go down. It's tough to make that argument. You always try if you need to, but it is tough. You should be aware of that. Okay, now, there's still more. The next thing I'll say to you is, wherever you are, you may be subject to state or local laws that give you additional protections and have different statutes of limitation. You will need to consult with local counsel for those statutes of limitation, because I will generally not be allowed to answer those questions for you unless you're in New York, where you're probably dealing with about a 3-year statute of limitations. So you might say to me, but my local or my state statute of limitations is much longer than the federal. Often true. Doesn't that make my federal statute of limitations longer? No, it doesn't. But it does mean you can still bring your case potentially under state or local law if you're outside your federal statute of limitations to file with the EEOC. But wait, there's more. And this is the last one, I promise. Under the federal laws, when you file with the EEOC, that is going to lock in your date. You filed, so now 300 days back from the day you filed is all the events of discrimination that can be included in your federal EEOC charge, and which will eventually be included in your federal litigation if you go on to federal litigation. But the EEOC takes its sweet-ass time in most offices. Not every office. All EEOC offices are not created equal. All EEOC employees are not created equal. There are wonderful, wonderful people at the EEOC. I can think of one mediator in particular who works out of the New York City office, and she is the heaven, the stars, amazing, right? But your average EEOC employee is barely functioning robot who doesn't give a shit about you or their job because they can't really be fired. So you'll find that your EEOC case may sit for months or years, and that's super, super frustrating. Now, while it's happening, remember, you can always have them issue your right to sue letter, or you can have your attorney pull your right to sue letter for you. But don't worry about your statute of limitations on the federal level while the case is pending in the EEOC. Do worry about your statute of limitations pending on the state or local level, because those may well still be running while the EEOC sits on your case doing nothing. Okay? Now, that's not always true. The EEOC does occasionally do wonderful things. Don't get me wrong. They also often do nothing on a case, wait a couple years, and issue a right to sue letter. That right to sue letter will be a new statute of limitations for your federal case. You now have exactly 90 days from the day you receive that right to sue letter to get your case filed in federal court. But that's going to be super weird because often people think it's from the date on the EEOC letter. It's not. Other people think it's from the date where the post office stamped the EEOC letter. It is still not. That is not accurate. It is from the date you received it. That's tough because there's not a lot of proof as to what day you received it. So, what I often tell people to do, like a crazy person, is when you get your right to sue letter from your EEOC, grab it, grab a camera, and grab a newspaper with a date. And take a picture of your right to sue letter with the date on the newspaper to prove the day you received it. Will defense counsel argue that you might have received it earlier and you're just now taking the picture? You waited time to take the picture so that you would have longer to make your 90 days? They might. I've heard that argument, but this is way better than just you saying, yeah, I received it on this date. Because the first thing out of the defense counsel's mouth is going to be, well, how do you know you received it that date? How do you remember that? Do you have any proof? What are you asking? You're asking us to believe you about the date you received something years ago? Because, I mean, your federal litigation could go for a year and a half. You could be arguing about this in a motion 18 months after you file, right? And they're going to be like, well, it's been a year and a half. How do you know what day you received it? You probably don't remember. Why are you lying? Why are you lying? Right? And defense counsel will, they'll make this argument sometimes. So rather than be at the whims and possible decency of a defense counsel, I urge you, when you get your right to sue letter, take a picture, timestamp it somehow, figure out a way to provide yourself evidence that you can keep that establishes what day you received that right to sue letter. Because if they can beat your right to sue letter and they can say you didn't file within 90 days, then you, my friend, are losing your federal claims. And that is not a good day for anybody. Is it necessarily true that your federal claims are more valuable than your state? No. Depends where you are. 100%. But we don't like to lose options. We don't like to lose options if we don't have to. Okay? There's tactical reasons why you might. There's things you might do. Like, there's decisions that get made. But don't do it because you didn't do a little legwork, right? Like, keep your options open. So I just threw a whole bunch of information at you. And I hope I did a good job. But if I didn't, let me know down below. I will try to clarify in the comments down below. Or if I have to, I'll make another video specifying. If anybody needs any part of this video, because I threw a bunch of information out there, if anybody needs any part clarified, I can make an additional video drilling down on things like the interplay between state and federal statute of limitations and how to keep an eye on that and stuff like that. There's a lot of things I can do here. I don't know what's interesting to you. I don't know what people will find helpful, but I do sincerely want to help you. And yeah, like and subscribe if this was helpful. It helps me to help more people just like you. And I'm sorry that I threw so much information at you and talked so fast, but I want to keep this under 10 minutes.